This video I'm going to take a look at non-compete clauses in contracts of employment. So if you're an employer or indeed an employee or a former employee, then you might want to have a look at the video just to be sure about how effective and how enforceable such non-compete clauses are. So let's take a look. Common law rights. An employer has a common law right to protect trade secrets and confidential information. So that arises from just a common law. It doesn't have to be in the contract of employment. It's not in statute per se, but there is a common law right. Also, an employer has a right to expect that the employee will not compete with him, the employer, while the employee is employed with him. The definition then of trade secrets and confidential information can cause problems, and this will depend on the particular circumstances of the case. Clearly, a lot of times disputes will arise because the employer will say that's a trade secret or that's confidential information. The employee may well turn around and say, look, everybody knows this is not a trade secret or whatever. As I say, there's no common law protection though preventing a former employee from soliciting business from former employer, and this needs then to be provided for in the contract of employment. That leads us on then to restrictive covenants. Restrictive covenants in a contract of employment are essentially non-compete clauses. The question I'm often asked is, how enforceable or how effective are they? Well, when you look at the whole situation in the round, there is a balance to be struck between restraint of trade on the one hand, the constitutional right of the constitutional right of an employee to earn a living, and the legitimate protection of a genuine interest of the employer. So there's competing demands, competing rights to be balanced out there in any dispute situation, and that ultimately is what will happen. If there's a dispute, the employee will simply plough ahead and commence business. The employer will seek to enforce his non-compete clause, his restrictive covenant, and a court ultimately then will be faced with the prospect of deciding between these two competing interests. Any restrictive covenant, any non-compete clause must be reasonable, and it must be reasonable as to the length of time and the geographical area that's sought to be covered. Time, 6 months is reasonable. Anything above 6 months is questionable, but you might get away with 6 to 12 months. However, the likes of 2 years, 18 months or longer would be hard, I believe, to enforce as being necessary and reasonable. The geographical area must be reasonable also, not an entire country, for example. Now, it is possible that you might be able to enforce one in relation to an entire country in particular circumstances, but by and large, employees, when they leave the job, are entitled to earn a living. They have a constitutional right to earn a living, and therefore the geographical restriction must be reasonable. If the employer is in breach of contract, then he will not be able to rely on any restrictive covenant. A further spanner in the works then comes from the Competition Act of 1991. This Act, Section 4, subsection 1 I think it is, prevents anti-competitive agreements between undertakings. Now, an employee while he's employed is not an undertaking. However, when the employee leaves the job and sets up in competition with the old employer, he's likely to be considered an undertaking and to be covered therefore by the Competition Act of 1991. Therefore, any agreement between the former employer and the former employee not to compete could actually be in breach of the Competition Act. It's anti-competitive. That's what the employee clearly would be arguing if he wants to commence. The leading case here is Apex Fire Protection versus Murta. It's a 1993 case. It's to do, I think, with fire extinguishers and the supply of fire extinguishers and fire protection equipment and so on. 2-year time restraint in this particular case was held to be excessive. 1 year you might get away with, but a 2-year restraint definitely was excessive. My name is Gorry. I'm a solicitor in Enfield in County Meath. There's my contact details there on the screen. I hope you find this video useful.